Hi guys, what do you have to spend your money on as a tier 1 entrepreneur for it to be a qualifying investment for the purposes of your extension application or your indefinite leave to remain application? The answer is these sorts of investments. So on office costs, for example, stationery or phone bills, travel costs, for example, fuel, parking, train or bus fares, clothing expenses, for example, uniforms, although I'd bracket that one, staff costs, salaries or subcontractor costs. I wouldn't be relying in terms of your salary on your own salary and your own remuneration. Financial costs, insurance, bank charges, stock, raw materials, costs of your business premises, advertising and marketing, and training courses. Now, the reality is, in order to show that it's a qualifying investment, we'll go to the rules in a minute, you only need to show your business accounts. There's some other very important points to bear in mind. But the business accounts for a small business, if you started your own business rather than investing 200k into a business in the UK, if it's your own small business, your accounts wouldn't generally show the particular payments. And your accountant wouldn't normally be expected to do that. So it would just be global figures. So there's a question of how does the Home Office actually assess whether the actual spending behind the accountant's figures was qualifying spending. And the rules basically operate by way of exclusion. Rather than telling you what you should invest in, they say what you can't invest in, what doesn't account towards the points award. But nevertheless, there is guidance by other government agencies, which is of perhaps indirect effect. There's nothing to show that this would directly be applied. But this is the list that I've just gone through, is from HMRC's list of examples of what are business expenses rather than expenses on you personally. And under previous iterations of the Tier 1 Entrepreneur guidance, personal remuneration has been excluded from your qualifying 200k investment. And you can understand why that might be the case, because if it's rather circular, isn't it, if the 200k goes back into your pocket, although having said that, directors' loans, etc. are permitted under certain conditions. So let's just have a look. Now I'd like to just start, before going any further, by saying, first of all, do feel free to contact me. I'm a lawyer based in London. I'd be very happy to assist you if you're looking at applying for a Tier 1 extension or for settlement under the Tier 1 Entrepreneur rules. The point I wanted to make here is that this route has effectively been closed down with some exceptions. So this is really of relevance to you if you've already got your initial application through. So extension applications for Tier 1 Entrepreneur applicants will remain open until the 5th of April 2023, and settlement applications until the 5th of April 2025. And now I know there are a great many of you out there. And I've just put this up because I won't read it all out, but this deals with the exceptions and other important points. Now, this is the bit that I really wanted to highlight. Let me just zoom in on this. These are the points. There we are. These are the points requirements if you're applying for a Tier 1 Entrepreneur extension. So you need to show, to get your 20 points for this part of it, that you've invested or have caused investment to be made by one or more third parties of at least 200,000 or 50,000. That's, if you had a seed funder, for example, those cases tend to be rare. So it's 200,000 for our purposes, in cash, directly into one or more UK businesses. You do not need to provide evidence of this investment if you're awarded points under this table on your last grant of entry clearance. Now, that would be rare upon an extension, that you had already been awarded points, in the sense of having already invested before your initial application in the company before applying. Now, it is possible to do that. In other words, you invest your 200k in a company and then you make your initial application for entry clearance. Why someone would do that, I do not know, but it has been done. It does happen. But that's rare. Most people will have invested in the company after their visa has been granted, as one might expect. So that's the point requirement. Now, what this boils down to is the specified documents. And let me just zoom in on this so you can see it properly. You must provide your specified accounts and accompanying evidence of investment. Now, if your business is a registered company which is required to produce audited accounts, the audited accounts must be provided with your application. If your business is not required to produce audited accounts, unaudited accounts, and an accounts compilation report must be provided from an accountant. Now, make sure that your accountant is qualified in a way that's specified under the rules, because there are applications that are refused on the basis that the accountant isn't a qualifying accountant for the purposes of these rules. And then if you have to produce further evidence, sometimes there's not time necessarily to do that. So you've got to get it right first time. Now, this says that the audited or unaudited accounts must show the investment in money made directly in the business by one or more of the following. Now, this is an interesting point, because the other day I spoke with a new client who I'm onboarding now, but unfortunately several months ago, when he was not represented, his family member made an application for a Tier 1 Entrepreneur extension, which was refused. The reason being that the 200k was transferred to one of the company's directors first and then into the business. So he was investing into an existing business rather than setting up his own business. But in this case, the money had been paid over to one of the directors, and then the director had used it to purchase shares on behalf of the visa applicant. What a disaster, because it meant that the application, the extension application, was refused, and he and his family had to return to their country, to the country of origin. And I'm assisting them in resolving the situation now, applying under an alternative route. But the lesson learnt by him was that the investment must be made directly in the business, quote unquote, directly in the business, not via an intermediary. The decision was a harsh one, because the Home Office must have, they have applied the rules very strictly, and that illustrates the point. If you've made the investment in the form of a director's loan, now that is probably really not to be recommended, but it is possible to do it in the way that's set out in in the rules here. I won't focus on that for the purposes of this video. If you've made the investment in the form of share capital, the accounts must show the shareholders the amount and value of the shares. Now, that is possibly the most straightforward way of showing that the 200,000 was made in invested and spent in accordance with the rules, because it's a share purchase agreement, and you'd show the SPA. But those are the specified documents there. As I say, the business accounts won't normally show exactly how the money has been spent, so it's unclear how the Home Office makes that assessment. Nevertheless, where people have encountered refusals, as I understand, are in relation to the use of intermediaries, and where accountants haven't been qualifying accountants. Now, let's just see if there's any important points that I can help you with here. Yeah, property. I mean, I've done a couple of videos on this channel about purchasing property, about the property exclusion, and where the boundaries of it are, both for Tier 1 investor and for Tier 1 entrepreneur. But the provision here says that if you've bought property as part of your business investment, the value of any residential accommodation cannot be included. That much is clear. You must provide an estimate of the value of the residential accommodation if it's part of the premises. yeah, so that's just a point for completeness. As I say, if you do want assistance with a Tier 1 Entrepreneur extension, where I haven't been instructed for the initial application, let's say, and or you are applying for a settlement, then please feel free to get in touch. There's lots of aspects of this which need project management and advice, including as well job creation and the jobs that you need to create. Where just very quickly, where there can also be issues is where people don't pay the minimum, where Tier 1 entrepreneurs don't pay their employees the minimum wage, or they're not able to show that they were paid the minimum wage for the full period, or where the job role has been cut short because someone has resigned early and they can't show a 12-month term for the role, and where else can people encounter difficulties? With right to work. Ironically, one of the challenges seems to be showing that right to work checks were conducted by the Tier 1 entrepreneurs or their businesses on the employees who are being cited in the extension application or in the settlement application. So in other words, were right to work checks actually done on those employees? And not doing right to work checks doesn't have any immediate sanction, but it means that if someone then, if your employee as a Tier 1 entrepreneur then overstays, for example, then you wouldn't have a statutory defence against a civil penalty, or indeed against criminal proceedings. So it's those kind of unexpected areas where Tier 1 entrepreneurs can be caught out, because there are still a great many Tier 1 entrepreneurs and lots of extension applications and settlement applications to be coming up to 2025. It's still an area to be monitored. Hope this was helpful. If it was, feel free to subscribe for more similar videos on this topic, and I will see you in the next video.